at least implied to me he had bonded out.
He wasn't on the jail roster this morning.
Okay.
And Judge, we did get a receipt from the on-call magistrate that bond was set. I didn't get confirmation that he did it.
Okay, so we'll call, we have a number of files for Mr. Ball set for the hearing at 9 a.m. this morning. File number 246733, 6734, and 6746. And if I could just have counsel put your appearances on the record.
Thank you, Your Honor. Good morning. For the record, my Columbia people.
Thank you, Your Honor. Richard Tewksbury, on behalf of Eric Ball.
And is Mr. Ball present here today?
I do not see him here in the board.
Okay. And just based on your statements that you have not had contact with him.
No, I did have contact with him on Friday.
Friday. Okay.
I met with him Friday in the jail. I confirmed with him the date and time of this hearing. We discussed what we intended to do, which was we planned to just ask for an adjournment. The court may recall we had asked for an adjournment because we were waiting on transcripts. Those transcripts just hit my desk last week. In addition to that, some new things have developed. There's at least one, possibly two new cases that are coming down against Mr. Ball. So for a lot of reasons, we intended to ask for some more time to sort some stuff out with that.
Okay. Mr. Ball.
Yes, sir. Thank you. There's a brand new case, a new false pretenses case. I'm sorry, new larceny by conversion case over $10,000 but less than $20,000 that has been authorized. That's the matter he posted bond on this weekend. We are also awaiting a sane report from 2 weekends ago that Mr. Ball was allegedly involved with 4 other co-defendants. That was a more serious concern because it not only involved methamphetamine but also firearms and ammunition.
Mr. DeLeo, do we have Mr. Ball on probation for anything?
He's on a delay of sentence.
A delay of sentence, okay. All right, given Mr. Ball's failure to appear this morning and the fact that he was recently in the jail, was very well aware of the date and time of this hearing today, court will request Mr. Roller that he prepare a bench warrant for his arrest. Once Mr. Ball is apprehended, then we'll proceed. Did he post bond in these files too? You know, Mr. Church?
Yes, he
including all of his files.
correct. Again, there was a probation detainer that was removed, I think, Friday, and he's posted bond in every other file.
Okay. All right, so the court will order that his bond, as to at least these 3 files, be revoked. Once he's arrested, the court will order that he be held without bond as to these 3 files until the court can schedule a hearing at the present. Anything further from either counsel on the 3 files involving Mr. Ball?
The only issue, Judge, would be when that supplemental hearing is done, how people will be moving for an accelerated sentence on the delay of sentence.
Okay. All right, thank you. Is Mr. DeShane present?
Sorry, it's just one issue I wanted to address in regards to Mr. Ball.
Sure.
We do intend to file a motion to quash. My intentions would be to file the motion, but as long as there's an open bench warrant, does the court want me to notice the hearing or not?
Probably not. Yeah. Probably.
Okay. I mean, I want to file it because I don't want to delay it any more than it has to be. But
Richard,
I think if you want to,
Mr. Ball right there.
Mr. Ball is here.
oh, he is. Okay. All right, Ms. Bose, we're going to, I thought we were going to have your hearing next, but I'm going to have to hold off just for a minute. So I'm just going to mute you, but have you remain here in the virtual courtroom, okay?
Okay, no problem, Your Honor.
Thank you. Okay, the record should reflect that Mr. Ball is now present. And so I know what you're going to do, Mr. Truth, but if you want to make a record with your client present.
yes, Your Honor. As I indicated earlier, we intended to ask for an adjournment for a couple of reasons. One of which is the transcripts that we needed to file our motion to quash have just come in. Took longer than usual because we had 2 full trial transcripts sitting in front of it. But those have just come in. Additionally, there were some new charges that have come down. One of them is currently in district court and the other, I think, just came down this weekend. So for a variety of reasons, we'd ask for an adjournment so we can explore potential global resolutions and file that motion.
Mr. Rowland.
Judge, one of the problem with that, the people's concern is the defendant took here at 9 o'clock and after the court on the record starts indicating about potential engineering issue, he decides in the end, or he should understand that these hearings are not an invitation, they're a court order, and I'd ask the court to address that.
I was very much going to address that.
I kind of figured you would. Thank you.
But you don't have an objection to the
No,
adjournment?
Judge.
Okay. With regard to the delay of sentencing, what's your position on that?
Well, it's an AG's case specifically for failure to pay child support, it's my understanding. We are waiting for the circumstances as to whether or not the AG's office is going to ask us to pursue that, because we're going to be here anyway. I don't have confirmation on that yet, but I did do some checking last week on that very issue. That looks like where it's headed, which is why I mentioned on the record, so the court will be aware of any events.
Okay, all right, thank you. All right, so the court will grant the requested adjournment as these files, and then we'll proceed once that motion is filed. Mr. Ball, as indicated, I had just revoked your bond and authorized a bench warrant for your arrest, and I was going to order that you be held without bond pending the next hearing because you weren't here on time. I'm not going to go forward with that because you did appear here this morning, and I mean, really within 5 minutes of your hearing time, so I'm not going to impose such a penalty on you this time, but you do need to be aware that that's what happens when you don't show up for your hearing. So if you want to stay out of jail, if you want to stay on bond, you need to be here on time and probably early so that you have time to speak with your lawyer, okay?
I genuinely am, Your Honor, and I'm sorry my ride was late. They don't have a chance to say.
All right, thank you. That's all for today.
Thank you.
Okay, Mr. Deshane, if you want to come forward, please. All right, we'll go on the record in People versus Sean Deshane, case number 246723. The record should reflect that Mr. Deshane is present here in the courtroom today. If I could have both counsel put your appearances on, please.
Thank you. The record on the people.
I actually think this is the attorney general's case.
Megan Boss on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Duchesne.
Mr. Trush, can you tell me the status of this file?
Yes, Your Honor. We are in a position now, at the prior hearing, the court may recall, we'd asked for a little bit of time. Mr. Duchesne had just been released from the county jail, having taken care of his misdemeanor matters. His business was just kind of getting back on foot, and we wanted a little bit of time to get a little stability before we entered into the plea agreement. The plea agreement is consistent with what the Attorney General generally offers in these types of cases, which is delay of sentence. If Mr. Duchesne reduces the arrearage to $19,500, it would be I'm sorry. If he reduces the support to $1,300, they would reduce it to a single count of attempt. If he pays as ordered and eliminates the arrearage, they would reduce it to a disorderly person misdemeanor.
Ms. Voss, is that a correct statement of the plea offer in this case?
For the most part, in order for the defendant to get a delayed sentence, he must reduce arrears to $19,500. Then he may plea as charged with a delay of sentence.
So I guess what's the current arrearage amount?
We are over 26,000 as of right now, accruing at, what was it, 177 a month? Yep.
Yeah, sorry, Your Honor, I must have misunderstood that. We're gonna need some time to get that down.
Okay. How much time?
I was under the impression that I was getting the year delay to make my payments. They were gonna monitor the payments, and at the end of that year was when I would face charge of either it being dropped down, dropped, so I think I'm confused.
All right, Ms. Foss, I just want to make sure that we're all understanding the plea offer correctly. A condition precedent to the plea offer is that the arrearages are reduced to 19,500. Is that correct?
If he wants the delayed sentence, yes. If he's unable to take advantage of that offer, then he may plead as charged.
Okay, so Mr. Church, do you want to have, I mean, I don't mind adjourning this out if you want to have some time to discuss that with Mr. Shane.
Yeah.
Potentially,
And I apologize. I obviously misread or didn't understand that part of the plea agreement there, that there was an upfront piece to it. And that's on me. So,
Ms. Foss, do you have any objection to adjourning this, given council's confusion or misunderstanding regarding the actual plea offer?
No objection, Your Honor.
Okay,
I have been making monthly payments, just so that's on the record.
okay, so that's good. We would definitely want that to continue. So Mr. Duchesne, I'm going to give you some time to speak with Mr. Trush about your options in this case, so that you're both clear on that before we go forward. So we're going to set this for another hearing date. In the meantime, of course, continue making those payments, okay? Anything further, Ms. Foss, on this file?
Nothing further, Your Honor.
Okay, thank you. You're free to disconnect at this time.
Thank you, Your Honor.
Next hearing is People versus Mandy Porter. Is Porter present? Porter, if you'd like to come forward, please. This is file number 226361. The record should reflect that Ms. Porter is present here in the courtroom today. And this is set as a probation violation hearing. Mr. Trush can tell me the status of this file.
yes, Your Honor. We're going to be asking for an adjournment on this, just to give the court a little bit of background. I spoke to Ms. Porter. Our original intentions were to enter a no contest plea today. The basis for the violation is 2 new charges. I believe they're still in the district court, but admittedly, there's some confusion as to that. When I spoke to Ms. Porter, again, she indicated to me she thought Mr. Brown was her attorney on those. I contacted Mr. Brown. He's not her attorney. I contacted Mr. Delo. He's not. He indicated to me that he had the files flagged, so I would be appointed to them when they came down. So there's some confusion as to where those other files lie. I want to make sure before we enter any pleas here that we know what's going on in the other cases. Additionally, Mr. DeLeo has suggested that if she takes responsibility in those cases, it's very likely they won't wind up pursuing the violation. So,
Mr. Leo, any objection to adjourning this out pending those other files?
No, I think that would be appropriate.
Okay. All right. I'm just going to set this for hearing in 90 days then. Obviously, if those other cases are resolved and this matter is dismissed, won't need that hearing. And if it's not, that'll give us a next date. Anything further on this file today, Mr. Trush?
no, Your Honor, I would just indicate, I mean, if Ms. Porter does want to resolve it, but like I said, I mean, I think it's more important we get it done the right way than just rushing through and getting it done.
Yeah, I agree. All right. Thank you, Ms. Porter. That's all for today.
Your Honor, the other way to get Mr. Carson.
Okay. Sir, what is your name?
Mr. Ritchie?
Richie, were you ready on that one? Oh, I'm sorry. That's Oh, this is. Mr. Ritchie, do you want to come forward to the podium, please? This is file number 236532, People versus Stephen Allen Ritchie. Record should reflect that Mr. Ritchie is present here in the courtroom today. This is a show cause hearing. Mr. Ritchie, it's alleged that you have committed a technical violation of your probation. It's alleged that you have failed to pay restitution amount of $480 and failed to make any payments on that. Mr. Leo, would this be first technical violation?
Yes,
So, Mr. Ritchie, I just need to go through a few things with you regarding
Yes.
your rights. You do have the right to have a hearing as to whether or not you should be found in violation. Because this is a technical probation violation, the maximum penalty you could face would be up to 15 days in jail. You have the right to have an attorney. If you can't afford one, one will be appointed for you. Do you know if you would like to request a court-appointed attorney? Or?
I don't think it's necessary, Your Honor.
Okay. How did you want to proceed today?
As far as,
Typically, or go ahead, Mr. Leo.
thank you, Your Honor. This is Mr. Brunikel's case. He indicated that Mr. Ritchie just made a payment of $800. He's got a remaining balance of $799.60 with 300% of the restitution. He's recommending at this time that we just adjourn this for 90 days to continue monitoring payments. If he gets them paid in that time, then we will dismiss.
Okay. Mr. Ritchie, do you have any objections?
I do not, Your Honor.
Okay. So what I'm going to do for today's purposes for the record is just enter not guilty plea on your behalf. Set bond as a personal or cognizance bond. So you don't have to post any money, but you do remain subject to the conditions of probation. And then just stay in touch with Mr. Brunikel over the next couple of months. And the court is going to set this for a hearing in 90 days. So it sounds like you may not need that. So
Yes,
just make sure you stay in touch again.
absolutely.
Do you have any questions?
I do not.
Thank you.
Thank you.
Right. Our next or the last three hearings of the morning all involve individuals who are lodged. So I don't see the jail connected yet. Once they're connected, we'll proceed with that. Take a short recess. All right, sir, there at the jail, can you tell me your name, please?
My name is Kyle Karsten.
All right, thank you. We'll go on the record in People versus Kyle Karsten. This is file number 246756. The record should reflect that Mr. Karsten is present today by video from Seagull County Jail. If I could have counsel put your appearances on.
Thank you, Your Honor. Recommend on the people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Karsten. Your Honor, we're here today for an arraignment on the information. I think I received it late last week. I assume Your Honor received it as well. We don't do a lot of these because normally the arraignment's waived at the bind over. In this particular case, I had discussions with Mr. Rolla. He was of the belief or felt that he had to declare a theory of the case at the bind over stage. So when we did our waiver, we requested that arraignment be done so that information could be filed alleging a specific allegation. It does appear there's been allegations alleged in the alternative. In regards to the arraignment, we'd waive a reading of the complaint and we would continue our plea of not guilty.
Okay. So Mr. Karsten, the court's going to enter a not guilty plea on your behalf with regard to all the charges in this case. In terms of proceeding with the file, Mr. Have there been any plea offers? Have you had any discussions with your client in this case?
I have not received a formal plea offer from the prosecutor yet. I have had quite a bit of discussion with my client up to this point. We've done quite a bit of investigation. I would indicate at this point, we're requesting a speedy trial. We're not waiving any of the timelines. And I would just ask or suggest to the court that we set a status conference, maybe 60 days or so down the road, but at least at this junction, we intend to proceed to trial and we intend to do that within the 180-day time.
Okay. Mr. Rolla, how much time do you need to be prepared for trial in this case?
Judge, we are still waiting the autopsy report, as I advised Mr. Truish on. There are some tentative, we've had discussions regarding the possible resolution of this case. Just though to correct the record, actually, since 2 shots were fired, there are actually 2 counts right now. That's really not charged, as I understand, in the alternative, but which is the other reason we're waiting for the autopsy to find out whether or not one or both of the shots were proved to be fatal. I would say at least 60 days, Your Honor, specifically because of those reasons.
Okay. If I were to set this for trial at 120 days out, is that sufficient?
But that would probably be sufficient,
Mr. Church.
I think that would be fine. And again, I'd ask a status conference, either the same month as the trial or preceding it. Like I said, as of right now, we don't intend to waive any timelines. I have discussed with my client, there could come a point when it makes sense for us to do that, depending on what the information looks like.
Okay. Mr. Truish, since you've had, as you indicated, a number of discussions with your client, are there any concerns regarding competency in this case?
I do not have any concerns regarding competency.
Okay. And then, Mr. Rolla, in terms of the length of the trial, how many days of trial?
Again, this is probably a 5-day trial, Judge.
I would at least say preliminarily, yes. I will disclose, defense is looking at least one expert. It's possible there's going to be more than one. Again, we're early in the case at this point.
Okay. I'm going to set it for a 5-day jury trial at about 120 days out because Mr. Karsten is lodged and likely will be. This case will have priority over the court's other files. So we'll get it on the trial calendar. I will set this for status conference at 60 days. And then I will set it for a final status conference prior to the trial, which would be the plea of motion cut off, as the court typically does. Mr. Rolla, are there any other dates that we need to set in this file?
The suggestion I would be is I would set the status conference at least 30 days prior to trial, Judge, if that's conceivable with the court docket, because I have a feeling at that hearing, a number of things are going to be taking place, which we're going to need some time for the defense, specifically as well as the prosecution, to perhaps then resolve this issue.
Any other dates for your side, Mr. Church?
No, I think in 60 days we'll be in a better position to maybe indicate to the court where it's headed. This is a complicated situation for everyone.
Okay. Mr. Karsten, have you been able to hear everything we've been discussing here today?
Yes, sir.
Do you have
Yes,
any
sir.
questions? Okay, do you have
No,
any
I do
questions?
not.
Okay,
No,
all
sir.
right, thank you. Thank you. The court will send out a notice of the date and time for that next status conference at 60 days, as well as the trial dates and final status conference date. And that's all for this file today. Thank you. If we could have Ms. Jefferson, please. Do you know if Ms. Jefferson's had any prior technical violation convictions?
I don't think conviction, she's got a couple of other probation violations pending right now.
Aaron, I think that concludes my portion of the docket, or any of the remaining things, arraignments you might need.
This one here is a probation violation.
I will stick around.
All right, ma'am, are you Heather Rose Jefferson?
Yes.
We're on the record in People versus Heather Jefferson. This is case number 236640. The record should reflect that Ms. Jefferson is present today by video from the Otsego County Jail. Present here in the courtroom is Mr. Leo on behalf of the probation department. And then we have Mr. Trush here as a duty attorney for purposes of arraignment. Ms. Jefferson, you're before the court today for arraignment on a number of different probation violations. Have you been given a copy of the alleged violations?
Yes, Your Honor.
Do you need me to go through those with you, or do you understand what the alleged violations are?
I understand.
Okay, I'm going to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you actually did violate your probation in any of the ways that have been alleged. You have the right to have an attorney present at any of your court hearings. We have Mr. Trush here, who is a court-appointed attorney who can represent you for purposes of this hearing today. If you can't afford an attorney going forward, one could be appointed for you at public expense, or you can hire your own attorney. If you are found guilty of any of the technical violations, the maximum penalty you could face would be up to 15 days in jail. If you are found guilty of any of the non-technical probation violations, that could subject you to the maximum possible penalty on your underlying charge, which is operating while intoxicated, third offense, which is 5 years. You understand all those things I've stated to you?
Yes, Your Honor.
Did you want to request a court-appointed attorney, or did you want to hire your own lawyer going forward?
I wanted to, I thought there was going to be an attorney here with me today. I wanted to hire my own going forward.
Okay, we do have, again, Mr. Trush, a court-appointed attorney here present. Did you want to have an opportunity to speak with him this morning?
I thought Larry Brown was going to be here with me this morning.
Have you hired him to represent you?
No, but I spoke with him the other day.
Okay. He is going to be here for a different case in about 10 minutes. Do you want to have an opportunity to speak with him yet going forward this morning?
No, that's okay. No.
Okay. All right. I'm going to enter a not guilty plea on your behalf with regard to these alleged violations. And the court will set this for a hearing. Between now and then, you'll have an opportunity to get your attorney lined up. In terms of bond pending that hearing, Mr. DeLeo or Mr. Rowland, any position or recommendations?
Judge, we would recommend a cash bond. As the court may recall, Ms. Jefferson has a couple of other probation violations pending right now, as well as she's currently out on bond of Isabella County for delivery of methamphetamine cases. So there's some significant concerns regarding her behavior and public safety.
Okay. Ms. Jefferson, was there anything you wanted to say regarding the amount of bond?
No, Your Honor.
Okay. Given the nature of the alleged violations in this case, which do involve at least possession of firearms and ammunition allegedly, the court does have concerns regarding public safety. The court finds that an appropriate amount of bond in this case would be $15,000 cash or surety, so the court will set bond in that amount. The court will set this for a hearing within 14 days per statute and court rule. And Ms. Jefferson, I will notify Mr. Brown when I see him this morning that, you know, that you may want to talk to him, okay?
Thank you, Your Honor.
Okay. All right, do you have any questions about how we're going to go forward?
No.
All right, thank you. That's all for this hearing today. And
Your Honor.
courts, yes.
If I may, Ms. Jefferson, I just want to make sure that you understand. If you do determine at a later date, you want to be screened for appointed counsel, you need to contact Mr. Gilo's office, Gary Gilo. You always have
Yes,
the
sir.
ability to come back and ask to be screened again if you either find you can't hire an attorney or if you just determine that you want to be screened again. Okay?
Yes. Yes, sir.
Okay. All right, thank you. That's all for this hearing today, and the court will disconnect from the jail at this time. Okay. Our next hearing is set for sentencing for Mr. Zolman. As soon as Mr. Zolman, as soon as your attorney, we're a little bit ahead of schedule. As soon as your attorney's here, we'll get started. Take a short break. That red podium there, Mr. Gibbons, thank you. All right. We're on the record now in People versus Bobby Joel Zolman, case number 246729. The record should reflect that Mr. Zolman is present here in court today. If I could have counsel put your appearances on.
Thank you, Your Honor. The record,
Or Your Honor, Larry Brown on behalf of Mr. Zolman.
Thank you. This is a date and time set for sentencing in this matter. Mr. Zolman, have you had an opportunity to go through the pre-sentence report
Yes,
with
sir.
Mr. Brown?
Yes, sir.
Okay. Do you need any more time to do that before we go? forward? Mr. Brown, are there any additions, deletions, or corrections to the report?
Not to the body of the report, Your Honor, no challenges to the score.
Roland, does this still have any additions, deletions, or corrections?
no addition to list of corrections to the body report, no challenges.
Thank you. Do you have any victims that wish to address the court? Anything on behalf of the people for allocation?
Yes, Judge, as I'm sure is blatantly apparent in court, this is a situation because of the application of the 10-year gap rule. Many, if not all, of the defendants very serious prior offenses penalties in that score. August 1992, police officer assault with intent to commit murder, burglary third degree, possession of burglary tools, felonious assault, as well as then later offenses that we had that new story we had for 2017. If those are minor misdemeanor offenses, had the prior felonies actually been scored, we would be looking at a guideline of 29 to 57 to life. But under the guidelines with the 10-year gap rule, it's 5 to 17 months. I asked for the sentence of the defendant accordingly to take those factors into consideration, because while I understand the 10-year gap rule is in fact statutory, so we don't dispute that, the court can also take into effect the fact that those things are not counted, and so the guidelines don't effectively address all of the factors that the court can take into place in the sentencing. Thank you, Ryan.
Mr. Brown?
Yes, thank you, Your Honor. I'm well aware of his history as well as the gap rule. However, I believe the 10-year gap rule was placed there by the legislature for a reason. And Mr. Zolman is 54 years old now. These offenses, the most serious offense, which he did 8 years in prison for, happened back in 1989, which my math puts him at around 18, maybe 19 years old, while legally an adult, still a kid. I think it is significant that when he was released, we don't see any type of parole violations, don't see any behavior problems while in prison that were noted. And given the seriousness of that crime, when he was released, his next offense was 17 years later. Given the seriousness of that crime, as well as one he's currently charged with, the only 2 other offenses he had, while not to minimize the crime, could be referred in relation to the current charges as petty crimes. We have an embezzlement, driving on suspended license, and a retail fraud. So the vast majority of his, what I would consider adult life, other than when he was maybe 18, 19 years old, he's been doing very well. He had a very, very good employment history. He was overcoming a lot of family issues. Doesn't really have any support out there. But he did put in 12 really good years. They kept him around for 12 years at Myers. So he has proven that he can do this. Quite frankly, in speaking with him, and again, this doesn't appear to be a drug crime. There's no substance issues to speak of here. For whatever reason, Mr. Zolman, in his own words, as he basically, his description, I was homeless, I had no money, so I got desperate, decided to rob a bank. He was in a very, very bad spot. He dealt with it in the wrong way. Quite frankly, this, in my opinion, was a desperate attempt at something. He had to have been going through some sort of breakdown or mental crisis, because he was clearly caught on video. The note was personally just kind of ridiculous. that anybody this day and age would just be able to walk in, know you're flat on camera, just give a no and get away with it. So I would ask the court to take all of those things into consideration when sentencing. I don't think he's beyond rehabilitation here. I think he can work. He just needs some help in getting his life back together. I would also, and this is an odd request, I've had it a couple of times, if the court is going to consider what the recommendation is, which I believe is about 12 months with credit for time served, Mr. Zolman has asked me, and so I am only doing this because he requested it, that the court at least give him a year and a day he would rather spend it in prison.
Mr. Zolman, anything that you wanted to say? No, sir. I did read through the report. I'm familiar with the facts of this particular case based on the information in that report. I'm also familiar with your personal history and background. There's a lot of information in the report about that. And I take all of that into consideration along with what the lawyers had to say here today. The court has a number of different goals that it tries to reach through sentencing. Number one is punishment, that there's some consequence when a person engages in improper and really dangerous behavior, as you did in this case. Deterrence, so that others in the community as well as yourself see that these types of acts are dealt with a serious consequence, and hopefully people will think twice before attempting something like this going forward. Rehabilitation is one of the goals of sentencing, and then of course the protection of the community, so that through the sentence you're not in a position where you're able to put people in danger by engaging in these kind of acts. Looking at all of those things, looking at the circumstances here, I don't find your past history to be that compelling because it is so long ago, and it does appear that for a long time you were able to conform to the requirements of society. You were working, supporting yourself, and you were able to do that over a sustained period of time. And I actually think that's a mitigating factor, not something that makes this worse. So I don't view your past history as all that significant. What I view as much more significant is your actual actions in this case and what you did. And when I look at the guidelines, I don't think that they're adequate to account for that. You know, that the court has an obligation to sentence you proportionately. In other words, that the sentence has to match the kind of behavior that you engaged in. And a sentence of 5 to 17 months, frankly, I was, and I don't think the guidelines are scored incorrectly, but I was very surprised at the guidelines being so low in this case, given your behavior. Because I do think this was a particularly serious offense. You placed the people at the bank in danger. Certainly the person whose car you were riding in, she had no idea what was going on. She was absolutely placed in danger. And then just the danger to the public in general. When something like this happens, there's an immediate and very substantial and serious response by law enforcement, and that in and of itself puts people in danger. So I don't think the guidelines adequately account for that at all. There's really, I think there was 0 points for any victims at all being placed in danger here. And again, while I think that's probably appropriately scored, it doesn't mean that people weren't placed in danger as a result of your actions. And I think that's significant. I think it should be scored, and it's not in this case. And I don't think that a 12-month jail sentence or a 13-month prison sentence really accomplishes any of the goals of sentencing. It certainly, to me, doesn't provide any kind of deterrence. If people think that they can rob a bank and do 12 months in the county jail, to me that does not accomplish the goal of deterrence. And it certainly, I don't think, doesn't accomplish the goal of punishment and provide an adequate consequence to you for your behavior in this case. So for those reasons, I don't find a sentence within the guidelines to be proportionate. Looking at the sentencing grid here, which is a Class C grid, I think if there were appropriate points assigned for the danger that you pose to the community and to the people who were directly involved in this during this incident. I think it would have resulted in many more points being scored on the OD levels. Probably would place you, in my calculation, in a range of 19 to 38 months. And I think that sentence within that range certainly would more adequately address the goals of sentencing, in particular deterrence and punishment. So the court is going to depart from the guidelines. I find, again, a proportionate and appropriate sentence in this case, 38 months to 20 years. You have credit for 124 days served. That's 38 months in the Michigan Department of Corrections. The court is going to order restitution in the amount of $70. It's payable to the Otsego County Clerk, be dispersed to the driver of the cab in this case. Crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost. If I didn't say it, you do have 124 days of credit. You do have the ability to seek an appeal of the sentence, and Mr. Brown can provide Mr. Zolman
Your Honor, he has acknowledged that. I'm tendering it.
throw in for the address for the record on behalf of Mr. Brown.
No, Your Honor, thank
Mr. Zolman, you are remanded to the custody of the state at this time. That also concludes our morning docket. The court will be in recess until 1:30.